You said it's neither one of them.
Sir, you
Did you
better
not?
go back to law school because I don't think you got the education you need to represent yourself.
Welcome back, folks. Today, we're back in Kansas with Judge Webster, a man who's seen just about every legal stunt in the book, and yet somehow, defendants keep finding new ways to test his patience. Our returning star, Isaiah Kerfin, who's once again determined to defend himself. Armed with questionable legal theories and a stubborn refusal to give a straight answer, this isn't just a routine hearing, it's a crash course in how not to represent yourself. From common law or admiralty confusion to jurisdictional gymnastics, we're about to watch a defendant dodge more direct questions than a politician at a press conference. And if you think this will be quick, think again, because this hearing is about to spiral into a masterclass of circular arguments, legal misunderstandings, and one very patient judge trying to keep the train on the tracks. Let's get into it.
We will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Kervin. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Kervin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Kervin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction. I had a question about that.
Okay.
'Cause I wanted to know the cause and nature of what's bringing the suit against you. I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that gives the court two ways? The Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime admiralty law? Which one am I want to be tried under?
This is where things start to drift into the sovereign citizen playbook. Notice how Kervin immediately bypasses the actual charge and dives headfirst into questioning jurisdiction. While questioning jurisdiction isn't inherently wrong, the way it's framed here is classic pseudo-legal rhetoric, asking what cards and nature the court is bringing against him, as though the entire proceeding is some kind of mystery game. the Sixth Amendment is tossed into the mix. But it's clear there's a fundamental misunderstanding between being informed and understanding. The court can tell you the charge, but it's not responsible for giving you a crash course in Law School 101.
Neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color
Admiralty, that is
admiralty.
correct.
It's neither,
That
it's
is
neither one.
correct. Neither
So which one, what am I going to be tried under? What jurisdiction I fall under, so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
Statutes, but under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, you know, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic of infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
Therefore, if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could...
And there it is, the dreaded admiralty law reference. If you've spent any time watching sovereign citizen cases, you know that the moment maritime law gets mentioned in a landlocked courtroom, things are about to go sideways. The judge has already explained this is a statutory criminal matter, but Kervin insists on framing it like a choice between two imaginary doors, common law or maritime law. It's a false dilemma, and courts operate under neither in this context. Still, we see defendants cling to these talking points, convinced that using the magic words will somehow get the case dismissed.
Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial. and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that would that be under? That would be civil? Would
Sir,
that be like
you consented by your conduct of going on to a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding when you say, like, when you said the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I had that not asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're missing.
Here comes a crucial point of law that trips up many self-represented defendants. The right to a jury trial. Kervin assumes it's automatic, but under US constitutional law, that's only guaranteed if the maximum possible sentence exceeds 1 year. His charge tops out at 6 months, meaning a jury trial isn't automatic. It must be requested in writing. The prosecutor even references case law that backs this up. This is a big moment because it shows how small procedural oversights, like failing to file a simple written request, can drastically change the shape of a trial.
By now, you should have had all your motions on file. We're ready.
Maybe misunderstood what I was
asking.
Please
don't interrupt to me.
I had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to
Before I get to that, I
represent,
had questions.
sir,
That's what I'm saying.
stop.
I had
Stop
before that.
interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Because I was trying to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be tried with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, then there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court only, the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, so it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. You froze.
I don't know if my phone froze or your deal.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully, so I can know how to defend myself.
Okay,
now.
You don't like my ruling.
You don't. So I had to. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I shouldn't know about?
Okay, sir. Here's the deal. You're either. I'm not going to play games with you. I understand the sovereign citizen position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking you how the right to defend myself under my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer. And I'm like, before I even go to trial, I like to know what jurisdiction I'm falling up under. And you're telling me how to find, in order to find out, I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment.
The judge's patience is starting to thin, and for good reason. Curvin is recycling the same common law or maritime question despite multiple clear answers. This isn't just stubbornness, it's a tactic often used to delay proceedings or create a record for appeal. The problem, it doesn't work when the arguments have no legal foundation. By this point, the judge isn't just addressing Curvin's confusion. She's pushing back against an entire set of internet-taught legal myths that derail courtrooms across the country. This is where the drama shifts from quirky to consequential.
Stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not
Yeah,
going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. And when I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me
I'm not
to?
arguing about the court. I'm trying to understand. I'm
If
still not
I
understanding.
cannot educate you and train you
I'm
on
not asking
law.
for educate.
If you want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for
I'm-
court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So what are you going to do on the issue of attorney? Continue to.
I'm just simply asking you to identify the code of the written law that you're asking to do. I'm just asking you which code is that you're bringing against me as constitutional law. Because if that's a civil law,
taking up time. Can you not understand what I'm saying?
you're asking me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going